Welcome. This is the 2019 KSB Policy Service webinar. If you are seeing a Hollywood Squares type of view and you just want to see our beautiful faces, the way you do that is move your mouse up to the square that has KSB School Law in the lower left-hand corner. Click on the three little dots, and as you pull down, there will be a choice for you to pin the video. And so if you do that, then you would just make it so you would see us large and everybody else would be small. As I said in the 2-minute warning, we have set it so everyone is muted and that you can't unmute yourselves. This is because we've had folks accidentally unmute themselves and then, cough or curse or whatever. So we will make it so that you can unmute yourselves when we throw it open for any questions, but while we're working through the policies themselves, we have you on muted. You can communicate with us directly using that little chat bubble at the bottom of the Zoom page, or you can text any one of us and we'll answer texts as we get them. Hopefully this isn't going to be super complicated because we were kind of pleased that despite all the noise and insanity coming from the unicameral, there isn't as much policy required changes as we were afraid there might be at one point in time. And so we'll just work through the changes and then let you guys ask questions. We're going to use the memo that you got yesterday as our template to walk through. So if you want to have something in front of you to kind of be going through as we're going through it, I think the policy service memo is a good thing to do. Or I think the stuff on the website is in order as well, so you can do it either way. Anything else? Oh, last thing, we're recording this and we'll have that recording edited and up on our website yet today, so that you can go back and look at it if you've got questions or if you have board members that for some bizarre reason want to be gunners and listen to us talk about policies, they can do that as well.
Oh, yeah.
Yeah, go.
The effective date of any of the legislation is 3 months after the legislature adjourned, so basically it's going to be September 1st, unless there's an emergency clause or some other specific date in the bill.
So,
Steve?
Oh, there you go.
All right, we start off with Policy 2002. This is one of the few areas where the unicameral decided to micromanage schools. They think they know a little bit better than you on some of the social studies and civics and those kind of issues. But in any event, your Committee on Americanism is no more. It's now the Committee on American Civics. Instead of appointing this committee at the beginning of the school year, it's at the beginning of each calendar year. The duties include, and you can see there is a laundry list, and we're not going to go through all of those. You can read all the specifics. But the more important parts are you now have to hold 2 public meetings each year. At least one of them, you must have public testimony. How testimony differs from public comment, I'm not quite sure. But there it is. You have to keep minutes, obviously, because it's a meeting. But those are the big changes there. The rest are in terms of the content of your curriculum, the content of specific classes, certain activities you're going to have to participate in for social studies, American civics. There's a summative assessment requirement for meeting state standards. Civics classes, American history classes. There's Bobby and I were talking this morning. You have to hold appropriate patriotic exercises on various holidays. We were chuckling because given the political divide in this country, one thing that's considered patriotic on one side of the aisle is going to be unpatriotic on the other side of the aisle. So maybe you have a rally and a protest at the same time that covers all of your patriotic exercises. We're just going to come kneel at all of your football games. One of the big pieces to this is every school board, the State Board of Education, and the superintendent of each school district in the state shall be held directly responsible in the order named for carrying out this section. Neglect thereof by any employee may be considered a cause for dismissal. So if any employee or the superintendent fails to do anything on this list, that's cause for dismissal. Is it just cause? I'm going to assume yes, that's what they meant. I wish they'd used for just cause, because that's what we have in our tenure statutes, but I think that's going to be good now. So just as a superintendent and as any employee that's in any of these areas that are covered by the bill, I read it because my employment's at risk. So I would encourage you to read it, distribute the bill to any civics, history, other related teachers who have any responsibilities under these acts, so they don't get caught by surprise and maybe get a little notice of termination come the spring. So The state board has been directed to adopt rules and regulations for these. Those obviously aren't out yet. They haven't had a chance to do that. But I suspect that those will be out relatively soon. So that is the change in 2002. This is you'll see in our policy, it's a very un-KSB-like policy. We debated whether we wanted to regurgitate the statute or not. Given the specific requirements of this bill, we thought it best to put those in there so you wouldn't be caught by surprise. So that's why you see a revision that we typically wouldn't do.
We also think that the VFW or the Center for Americanism or whoever the heck may be asking schools to prove that they've complied with this law, and so we thought having this policy for you to hand them might be good. We did talk internally that someday we might carve this down a little bit because it is way longer and more detailed than like our policies. Okay, 2006 is me. It's 2006 is I believe, most important policy in the book for your board members. I think every board member should have a copy of 2006. I think they should. It's one of the few policies that I can off the top of my head say the number because it's just an important policy for you to be able to manage patron complaints. What we've done with 2006, this year we had 3 different circumstances where parents of special education children were unhappy with decisions that the IEP team had made about how to educate their kiddos. And then instead of working through the administrative process that they have as special education parents, they decided to file a complaint with the Board of Education. And then board members were kind of caught flat-footed because although 2006 says we're gonna work through the process and the board's gonna decide, we're whispering in their ear that there's nothing they can do because this is an IEP team decision. So, and I could understand why both board members and patrons were confused and somewhat frustrated by that. And so we have put now into 2006 a new section that makes clear that if the parent of a special education child that has an IEP or a disabled child that has a Section 504 plan, if they are complaining about specific educational services being provided to their kid, that the complaint process for that complaint is the administrative procedures that are set out in Section 504 of the Rehabilitation Act or Rule 51 for the IDEA. If they're complaining about like the general climate for disabled kids or disability bullying, or just you're not doing a good enough job as an entire district for the rights of disabled children, I think that could still be a 2006 complaint. But if it is, my kid needs phonics and you are teaching her a whole word, that's a pedagogy complaint, that's part of the IEP process, and that's not really appropriate to run through Section 2006, or Policy 2006. The other reason we put it in there is because, and for those of you that are sped nerds, this will make sense, and for the rest of you, you can just drink a coffee and a deep breath. But under the Fry decision, the idea that parents would be able to sue a school district for services under Section 504, even if the IEP team has decided the kid doesn't need those services, we want to drive all of those complaints through the IEP process and not let them also go to federal court. And so 2006 is also designed to drive all of those Fry complaints through the 2006 process. So that's what that is. Just added mostly to make it clear to special ed parents and to board members that IEP decisions get made by IEP teams, not the complaint process.
2 quick things. Put a star by that one when we talk about the Title IX regulations later. It's going to impact this, so it could be that we have a mid-year change to this policy, so you're going to give it to your board and a couple months later it might come back. We also got a question back on the Americanism bill saying that it reads a little bit like if the high school social studies teacher is given these directives and doesn't comply, that could also be cause with respect to that individual teacher.
I would say that's absolutely correct.
Right.
Yes.
So, you know, how you're going to delegate the requirements under the Americanism bill absolutely is going to have legal significance in that sense.
It'll be an interesting legal question because K-12 teachers don't have academic freedom in Nebraska, but they do have First Amendment rights to freedom of expression and freedom of thought. So I don't think we can fire somebody for not loving America, but I think we can fire them for not teaching about loving America, which is super weird, but there you have it. There's something on the chat, so I'm gonna look here. Do we continue with the committee on, oh, yes, Steve, this is too. Oh, sorry.
Continue with the Committee on Americanism in 2019 and make the change to the Committee on American Civics at the January board meeting. That's a good question because you've already got your Americanism committee in effect. You don't have to appoint these until the beginning of the year. I think probably that's accurate, is the requirement
You
to
don't
appoint.
think the September first date's gonna,
I don't think so, because you don't have to appoint that committee until January first.
oh, I see.
And so the next January first, so I think you stick with what you have, and go forward with the new committee on January first.
But it says by January first, right? So in theory, you could start complying with the new bill in September.
Sure.
I mean, that's the question that you have for your board, I suppose, right? Is when do you want to start checking stuff off this?
I mean, certainly the safest approach is come the new school year, get that stuff in place, in advance. The problem is, I don't know that you have enough time to make all the curriculum changes if you've already put those in place. The way I read the timing of the bill, I don't think you have to, but if you have time to do it, that certainly would be the safest approach, and probably what was intended.
Okay, on to policy 2014. This one's pretty simple. We did some cleanup at the beginning of it, removed references to school attorney, to legal counsel, just because that's the plural. And our policy has long said by request that basically the board will select, designate something a legal counsel, either at its January meeting or at some point throughout the year, like when you pay your bank and all that stuff. That's not legally required. What we need is, or any school attorney or any attorney for that matter needs, is authority to serve you. So that motion does accomplish that, but we just kind of clean that part of it up at the beginning to say, you know, if you work also with a local counsel on some issues, or if you have, you know, any desire, any need to contract with a different attorney at some point throughout the year, you can do that. The most important thing for us, though, the change here is that given what's going to happen with Title IX and all the craziness, if you have a situation that comes up like a personnel hearing where you don't have a board meeting before that hearing, but you need to hire a hearing officer, this policy now gives authority to the board president and superintendent to make that hire. So that's the main change, nothing too crazy. The next one, 2017, is one that we actually debated on whether we should have it or not, to be honest with you. The statute referenced in the memo, 79.516, which is hyperlinked if you're looking at the digital version. That's probably one to look at and to provide your board at some point, just kind of as a reminder. But essentially what it says is the board has very broad authority to do things like buy liability insurance, or even provide things like defense costs or pay judgments on behalf of board members, employees, and agents of the school if they find themselves in some kind of legal proceeding. So most schools have insurance against, you know, a slip and fall that happens outside of the school. This is the statute that authorizes that to happen. We put this policy in place because it outlines kind of the gist of that, but the board can also, after the fact, agree to indemnify somebody who's been through that process, and in other cases they have to. So if you have an employee that is, you know, that a parent gets upset because they strong-arm their kid in the hallway, and they can convince a county attorney who's a friend of theirs to press charges, if that employee beats those charges and it's determined, no, they used reasonable amount of force, that employee can actually submit a bill to the school asking for the school to cover their defense costs. And I think Steve's had it happen before where somebody made that request, and the board ended up having to provide it. So this statute does a lot of that, and I think you should be familiar with it. We included it because there are a lot of circumstances where either a superintendent or a board agreed to provide defense of somebody up front, like in a PPC complaint filing, for example. And so this policy just makes clear how the board goes about that and the authority that you have to procure legal services for any defense that the board, or in limited cases, the superintendent wants to provide. So in addition to being in things like, you know, superintendent administrator contracts, that you get a defense, this policy also then kind of lays out when the board or superintendent could provide it outside of those times already.
We have also had 2 occasions this school year where a non-NSEA teacher, not an NSEA member teacher, had a PPC complaint filed against him or her by a parent that we thought was unjust, the administration thought was unjust, that they wanted to provide that teacher with legal assistance to defend a PPC complaint. You have that authority as, well, the board has that authority, and this policy now makes it clear that the superintendent can say, yes, Mrs. Teacher, we will let KSB represent you, we'll pay for it, because we think you're getting a bad rap.
Okay.
So this next policy is the longest policy that you'll never use in the book. This is a policy that is required if you're going to use federal funds for construction and remodeling. And really, the meat of the policy is only required if you're using federal funds for construction or remodeling, that is going to have a total cost of greater than $250,000. So, but we do have, some districts that have used, federal funds because it's mostly, schools that are mostly Native American, that have had the ability to access federal funds for construction. So this policy is important for a small number of school districts. And then included in the federal funding guidelines are all these stupid things that you have to say, like minority preference, veteran preference, Buy America. And so we have all that in the purchasing policy, but one of our school's auditors that was doing a construction project with federal funds told us that she thought it would be better if all of that stuff was replicated in the construction policy, and I think she's right. So that's the main change in this. We've taken all of those like catch-all provisions from the purchasing policy with federal funds and dropped it into the policy with federal funds. There's a couple tweaks that are specific to like record retention for construction with federal funds that you might look at if you're doing a project like this. But honestly, most of you are just gonna adopt it and it's gonna be one of those stupid policies that just lives in your book just in case. But I don't think many of you are actually going to use it.
And by stupid, she means well thought out and required.
I'm not gonna rise to that. So,
If you've had any federal programs review, or if they send up those folks from Texas to, your school, you
The
know
school
what we're
lunch
talking
people,
about. Yeah.
so, but this is like, yeah, so this is that school lunch audit, but it's just all that stuff dropped into a construction policy. So that's 3003.1. 3004.1 that's the policy we're talking about, the purchasing with federal funds. When I was going through copying and pasting from one policy into the next, I found a typo in the purchasing policy. And I will tell you that kind of mistake is what made me so crazy. That is why I wanted to have a service, so that I could fix it for you all instead of just feeling bad about it. So literally, the only change in 3004.1 is fixing a typo that stupid autocorrect did for me when I first drafted the policy. So, but I would like you all to make that change because I don't like having ugly typographical policies. So that's that. Smoking.
Our next policy is smoking. We have debated, and probably at some point we will change the title of this policy because it's no longer just smoking, it's tobacco smoking and everything else related to it. This year there were two bills that were passed and they criminalized the use of what they are calling electronic nicotine delivery systems. Vape products is really what it used to be. And they crossed that, the vapor products provisions have been crossed out and they now use this new term. And so we have incorporated that into the smoking policy to make clear, and we've added a few other terms in there just to make clear anything and everything related to smoking, chewing tobacco, vape products, anything else. You've got three options. Two of them basically say you can't do it, or one says you can do it in certain places. Interesting note, they made it illegal in one bill for people under 19, the other under 18. That's rather confusing and inconsistent, but just remember there are three options under this policy. There's nothing worse than when we go to your websites to look at your policies and you adopted all three. Pick one, please. And so that's the change to policy 3060. And put a little asterisk by this one. We're going to talk about this a little bit later under the student discipline.
Sex offenders.
Oh, I'm at sex offenders. Yes, of course they assigned this to me. Basically, what happened, we've got several questions. The second paragraph under this policy required schools to give notice to people within the community that, hey, a sex offender's moved into town, here's where they live, and that kind of thing. That was removed many years ago. You're not required to do that anymore. Some schools want to do it, some don't. So if you want to do it, leave that second paragraph in and continue to send out that notice. If you are tired of doing that, it doesn't interest you, it's not what you want to do, take out that second paragraph and you don't have to send out those notices.
For those of you that have implemented our full policy service, it's probably one of the questions I get most often. Man, we thought we didn't have to do this anymore. Do we have to do it? We've left it in there mostly because if you have that parent, so let's say that you put one link in the first newsletter of the year. You've got that parent that comes in March and says, how could you not tell me that there's a sex offender living 2 houses down? I thought the school was supposed to do that. Your response can be, we did, right? It's always, we put it out in the newsletter. So Steve's right, not required, but a lot of schools that I talk to about why we left it in there still do it. So
Yeah, and the question I get is, when the change was first made, can we still do it? So My perception was that the majority of schools wanted to have that ability, but if you don't, Steve's right, take it out. I'm next with 3039. So 3039 goes with a big change that's coming later. That's an option for you all on law enforcement units. With all the school violence and all the concern about school safety, there's been an increasing sort of push from the law enforcement side to make it so that schools share more information more freely with law enforcement. For example, I've gotten a call probably 5 times this year. Can we just give the police department a link to watch our videos live in the hallways, our security videos live in the hallways? And the answer is, under FERPA, you can't do that, but there is a way to make that happen, and the way to make that happen is to sidestep FERPA by using what's called the law enforcement unit exception. So we're gonna talk about that later, because we have a whole policy if you wanna use the law enforcement unit exception to make things more releasable to the public and to law enforcement. What this policy does, if your board decides to adopt the law enforcement unit policy that we're gonna talk about later, you could also put into your threat assessment policy that your law enforcement unit is going to do your threat assessments. So if you say, we designate the assistant principal, the guidance counselor, and the high school principal to be our law enforcement unit, you could also then say in policy 3039, and those 3 people are the ones who will do the threat assessment if we're deciding if the kid is dangerous or not. And if you're one of those districts that's not wanting to share everything with law enforcement all the time, then you don't even have to worry about 3039. So it's an additional option in 3039 available to school districts that select the law enforcement unit option. Does that make sense?
Yeah, there were already 2 options in there.
Yeah.
So this is now kind of
A
a third
third
option, which modified the second, so you'll be familiar with it. It's part of any safety and security protocol.
Yeah. And we did tweak the first 2 options, but that was just like, since we're revising this anyway, let's make it better. So the changes in the first 2 options are not significant, like substance. So.
All right, policy 3046, animals at school. We had 3 policies that talked about animals, and they were all causing confusion. So what we have done is taken all 3, put them into one policy. Hopefully we'll have a little less confusion. We're talking about service animals, we're talking about animals generally, we're talking about therapy dogs, but what we used to have, we changed that now. So the first section is about the instructional use of animals. We actually didn't have anything that said, yeah, you can bring your fish or whatever, snakes and have those in class, like classroom pets. So that'll cover that. And again, they have to get permission from the administrator to have those in the first place. The second section of the policy now addresses service animals. It's identical to our previous policy. We didn't make any changes to it. I would like to note, we had changed the animals policy from policy 5060 to policy 3046 last year or the year before. A lot of you were asking questions about 5060. If you have that, that should be deleted, period. So make sure you get rid of that. The third section talks about therapy animals. We're getting more requests than just for therapy dogs, so we're now expanding that to therapy animals. And we essentially have 2 options. First one is an animal brought in by the school employee. And it has to be for the benefit of kids. So it's not talking about a therapy animal for an employee brought in by an employee. It's brought in by the employee for the benefit of kids. The second option that we've given you is that there won't be any therapy animals except as required by law. You can do various permutations of this policy anywhere in between those. And so if there's something you want to do that's not in there, please let us know. We're happy to do that. But we thought these were the 2 most likely, the 2 we run across the most often anyway. And so those are the 2 options that we've given you by default. So we would encourage you to take a look at those. If you want to do something different, just let us know.
And what we would say too is that we tried to develop this so that it was kind of best practices for the typical request, but it's not necessarily exhaustive of all of your obligations under the law. So when you get a request for a service animal or therapy animal, something like that, it's still worth it to maybe run it by us because we may not have expressly addressed it in this policy, but you may have an obligation under, for example, the American Disabilities Act to engage in the interactive process, come up with a reasonable accommodation. And we want to make sure that we're still following that. But to get into every permutation of that would make the policy cumbersome. So it's not necessarily exhaustive of all of your obligations.
I have two things to add. One, I'm surprised how frequently a superintendent, even a superintendent of not that big of a school, does not know that the librarian is bringing her golden retriever in on Fridays for kids to read to. So, and that would be covered by this policy. And you should at least know, because when mom wants to bring the golden retriever in, who's not a service animal, that's a pet, but it makes Cody feel better, we can't, it's gonna be way harder for us to say no, and we look like dorks if we say no, and we don't realize that there's already a dog coming in up to the library on Fridays. So this should be your cue. I believe every single one of you should ask your building administrators or your staff, does any teacher bring a furry friend into the building at any time during the school year?
Other than Steve White.
Oh, no. And he's not friendly.
I think a comment about Bobby and Turtle.
We got a check question, okay.
So that's your homework. All of you check and see what is happening with animals coming into the building now, because you may not be aware, but that is going to impact whether you say no to a family request. And the second thing I was gonna add is that Cody's doing a whole session on service animals at the school law seminar. And this is an issue that's just coming up more and more, so I would recommend that you do a little training on that. Okay, question. Therapy dog, staff owned or family student owned dog?
The way it's set up here is it's a staff-owned dog. Now, if you want to do a family or student one, you certainly could. The way we have it set up here, that wouldn't be allowed. And so if you wanted to do that, we would have to make this a one-off policy for you to make sure it fits.
And this goes back to the federal law compliance issue too, right? Because their reason for requesting it is significant.
Yes.
So that's why we didn't put in there in any request from a family needs X, because you could be going down 3 or 4 different paths. You know, are they asking for IDEA for 504, or is this just because, you know, we have an alternating bring your pet to school day? Knowing why they're making the request is legally significant.
Like, for example, our policy talks about therapy animals to benefit students, right? But under the ADA Title I, as a reasonable accommodation for an employee, they can ask for a therapy dog, and then you're gonna have to engage in that process. We're gonna help you to evaluate whether that's appropriate. The policy doesn't necessarily address that.
And we also, before you fiddle with it, call us, because like saying therapy dog, probably you're saying yes also to a therapy snake. Because the federal regulations talk about a service animal being a dog or a miniature horse, but a therapy animal is
Could be
an
any
animal. Yeah,
So like,
hamsters, turtles,
hamsters,
fish.
turtles, fish,
Yes,
that-
that's right, Mike.
like if it's for educational purposes, basically it's classroom pet, that's section 1. If we're talking about a therapy hamster, therapy turtle, therapy peacock we found, therapy parrots.
So, no, reptiles were where I got totally down the rabbit hole. Bearded dragons are very popular therapy animals.
So you can get a request for any therapy, you name the animal, it's been used as a therapy animal somewhere. So yeah, those requests could come.
Okay, we're waiting for more parent, well, so that's the question. So we've had parents bring the dog to school activities and take a big old dump in the walkway to the football field. So the AD says, well, you can't bring your dog anymore. And then mom says, oh no, this is my therapy dog. And it's like, no, you're just too lazy to have your dog crap on the floor at home. But I mean, so that's the question. If you let a parent bring the pet to school activities, that's cool. But then it's gonna be harder for you to say no to the kid that wants to bring the dog to class because of allergies or poop or what. It's just, there are implications to saying yes.
And the default provision in these 3 sections is no, they can't bring a pet to school without your specific written permission.
Because that's what we assumed both of you wanted. Okay, I think that's it. So I'm gonna close the chat box, check. Oh, I'm next. Yeah, so this is 3050 deals with basically Alexa in the classroom. We have more and more teachers bringing these smart speakers into the classroom. What's really interesting is Google and the manufacturers of all the smart speakers have said to the Federal Trade Commission, these devices are not designed for use in the classroom, so don't worry about it, FTC. That's not really the purpose. But then they sponsor presentations at ISTE and FETC telling teachers, 30 cool things you can do with Alexa. So we have fiddled with the Alexa part of it, the smart speaker part of it, clarifying that the teacher has to get permission from an administrator before he or she brings it to school. And then also we've made some changes to make it more compliant with the Children's Online Privacy Protection Act. And then the other thing that we've had happen is, parents who have kids using those Angel Sense, like the monitor if the kid is somebody that flees, that will monitor where the child is. Those Angel Sense and other devices have the ability for the parent to turn on a speaker and listen remotely to what's happening in the classroom, which is a violation of the Wiretap Act, and also, we think, just really bad educational practice. So we've made it clear that, if a parent sends a kid to school with one of these devices, they are obligated to allow us to have the code to make, because Angel Sense now allows schools to have the code to override whatever the parents have asked for, to turn off the recording ability. And so that's gonna be a requirement for a kid to bring one of these Angel Sense devices to school. We probably have, oh gosh, I probably had 20 calls on Angel Sense in the last 3 years. And I know not everybody calls every time a kid comes to school wearing one. So this is a pretty common issue. And
There'll be more on that in the recording. We have like a recording in the classroom policy for students later, just.
Yeah. So that, I think, is that? Oh, this is me. Oh, this is the, okay. So this policy took me way longer than it should have for a policy that's optional. We have had schools ask us about having the school nurse stock Narcan, which is an opioid arrestor, which basically if somebody's having an opioid overdose, you squirt this nasal spray in their nose and it immediately stops the overdose from happening. In 2015, the unicameral passed a law that says you can administer Narcan without having any kind of medical license. The Department of Health and Human Services also now has a standing order that they've issued, so that basically anybody that wants can walk into any pharmacy in Nebraska and get this. They have a nasal spray and they also have the injector, but the nasal spray is cheaper and easier to administer. So anybody can walk into any pharmacy and get Narcan. You don't have to have a prescription or a license. But the question is, so schools can have Narcan, should they? And if you are a school that wants to be able to stock Narcan, this policy exists so that you can have some guide rails to protect you if you decide to go ahead and administer it. There is training that you're supposed to have to be able to administer this stuff. I watched it. I feel like I could now squirt the inhaler up Bobby's nose if he was having an overdose. But you should require them to get that training. It's free, and I have a link in the digital version of this memo that would take you to the training. There's also a protocol that the National School Nurses Association has issued for nurses who want to administer Narcan, so I have a link to that. The only other thing I would mention is, once you stock a medication, you're gonna be obligated to make sure that it's up to date and you have, logged it and done all that stuff. So the DHHS makes it sound like this is a totally risk-free, cost-free way for you to be able to make sure people are safe. I think there are some administrative costs, but if your district wants to be able to stop Narcan, 3053 is designed to allow you to do that.
And if you're on the website and you go look at the forms, Karen's got 2 of these in there that she mentioned, the standing order, which allows you to get it, and then the sample protocol. So I think some of them are linked and some of them are also in the form. So if you're gonna talk to your school nurse about what your plan is gonna be, I would probably provide a copy of those too.
Yeah, and Dottie, 100%, this is optional. Yeah, I see you just typed the wrong number. This policy, the policy on stocking Narcan is 1,000% optional. If I was on a board of education, I'd have to think long and hard to decide whether I wanted to have this policy on the books or not. Stephen, according to all the medical stuff that I read, squirting the Narcan in somebody's nose or even injecting it into their muscles will have absolutely no effect on someone who's not having an overdose. The biggest concern that I read in the medical literature, and again, I spent way more time on this than I should have because I wanted to make sure I knew what I was talking about. The biggest danger is that if you give this to someone who is overdosing, they immediately lose their high, and there have been people who have committed acts of violence against law enforcement who've administered it because they're mad that they've lost their high. So the protocol recommends that even before you administer it, you dial 911 so that the cops are there in case the person gets violent or aggressive after they have been administered the Narcan. But, according to the medical literature I've looked at, there is absolutely no danger of giving this to someone who is not overdosing. The danger is that you think somebody's, overdosing and they're really having a heart attack. But the Narcan effectiveness is pretty immediate, so if you give it to them and they don't, seem to come around, then you start, doing CPR. Any liability for not administering if you have it, I put in there's a numbered, part of the policy about, a paragraph and a half down that says the district is not liable for not administering if we don't give it to you, you don't have any, we just decide to not do it anymore. And so I tried to write the policy to give you as many outs as possible so that you won't be liable for not administering it if you have it. But in the end, that's gonna be a fact fight.
This is just like the AEDs.
Right.
Right? You all have AEDs, but you might not have anybody on staff that can use them. At least for the most part, you can get training for this, which is why it's a little bit less prescriptive in that AED policy. But Stephen, your question is exactly why those policies seem longer than they should for having a safety device in school.
If I was on a board, I know I would vote against having AEDs. I'm not sure how I would vote on Narcan. I think it would depend on the community. But I can tell you that, there's no guarantee that you won't be sued, but I think we've got this as tight as we can. Last thing I'll say on this, there is someone who is an expert at GHHS on Narcan, that's like all she does. She says that there are programs, where schools can get, the stuff supplied basically for free, but it's on a first come, first served basis. I have a link in the memo to that page on the DHH website that walks through your options, and it just has other information on Narcan. I would probably, if I was a superintendent, assign my school nurse to figure this out, but there are options out there to get, Narcan, either at extremely reduced cost or even for free. Is that it for me?
Next one's mine. So we periodically get calls like, hey, KSP, hey, Cody, I have a clear list of procedures that I have to go through when I want to purchase something, and I have clear authority for what's in my budget, whether I'm authorized to it, but there's no policy that enables me to go out and either lease equipment in or to be able to lease out district property when it's appropriate. So we went ahead and created this new policy 3052 that basically provides the authorization for the superintendent to enter into lease agreements when they want to acquire property on a temporary basis rather than purchase it. If they need some for snow removal, if you need a backhoe for a short-term project, things like that that the district doesn't want to buy, but you need to acquire. This sets out a procedure and authority for you to do so. You'll notice that there's two parts. The first part is leasing property into the district. The second part is when you have excess property or equipment that you can lease out to generate revenue for the district. The first part somewhat tracks our purchasing policy. What I would say there is, to the extent you're using federal dollars on lease expenditures, it's cross-referenced into the federal policy. So there's a separate federal policy for acquisitions, which also would apply to leases. If you're using those federal dollars, I'll use the example we were writing the policy, your oven goes down, you don't want to have the expenditure in the middle of the year for a new one, you acquire one to put in the kitchen and you're using those federal dollars as part of the school lunch program. Want to make sure that you look at the federal leasing policies for that. Obviously give us a call on something unique like that. There's one provision that you need to pay attention to on the acquiring property, and that's basically to set a threshold of when the district will require written quotes, or more of a competitive bid process. It doesn't need to be like you're building a new gymnasium, but you want to have some point in there where you're going to require written bids, and that's a policy question for the board. Is that a $5,000 lease, $10,000 lease? At what point can you just take the one that you think is reasonable versus where do you need to go through some process to ensure that you're being good stewards of the district funds? And then the second part is if the district has excess property and wants to lease that out, this enables the superintendent to be able to do that. Again, there's going to be a policy decision about based on the current fair market value of the equipment or property being leased out, when the superintendent can just do it based on the terms and conditions that they come up with versus when they're going to need authority from the board to be able to do so. Again, that's a threshold drawing exercise for the board. If it's $3,500, $5,000, $10,000, that's going to be something you're going to have to take a look at. It's also going to ask you to basically decide what's the maximum number of days the superintendent can lease equipment out for. So at the time a lease is entered into, in order to be able to lease the equipment out, you're going to have to show that the district doesn't have a present need for that, which is fair at the time you make the lease. But you want to make sure that someone's not letting
leasing out a mower in January because you don't need it right now, and then the term of the lease is 4 years, right? So that during the reasonable timeline of the lease, is the district gonna need it at some point, or is the district gonna need to revisit the terms of the lease to make sure they're competitive? So whether that's 30 days or 60 days or 120 days, that's a policy question for the district to consider. What I point out here, we didn't put it in the lease, but I think it's important the superintendents to think about is who's gonna bear the risk of loss and liability for using the equipment. So if you're gonna lease out district property, that's a district asset, I would make it a requirement, particularly if it's valued above, $500 to $1,000, anything above your property deductible, I would wanna make the lessor pay for the property insurance if that equipment's damaged during their use. And also to have liability insurance so that if they're borrowing the school's snow removal equipment to do their commercial parking lot, and someone gets hurt from that the school's not on the hook from a liability standpoint. So we can help you navigate through that as you come up with a leasing program, or if you find that there's a lot more frequency, but this is an initial first step to give you the authority. The other thing is that in our judgment, we thought that that the frequency of leases that the districts can enter into is much lower than your general purchasing frequency. And so we contemplated that it would be the superintendent or the board that would be making these decisions and not delegate it down to building principals, department chairs, and things like that. So we're happy as you think about these things to work through with you to help it reflect your current practices or to address kind of details that you may be thinking of that you overlook.
This also does come up fairly frequently when the school has a really nice activities bus and the Catholic school in town makes state and you don't. And so they ask to borrow the really nice bus. So we also have like the quilting club asked to borrow school buses in the summertime to take everybody to the new fancy quilting exhibit in Lincoln. So school vehicles getting leased out actually comes up fairly frequently. So it's something to think about when you're looking at those numbers. If you're like, well, anything over $5,000, of course we should have board approval. Well, that's cool unless you don't want to have a special board meeting after district basketball when the Catholic girls make state and the non-Catholic girls don't.
And when you're leasing out the district property, the dollar amount you're looking at, it's not the dollar amount of the lease, it's the value of the equipment.
Yeah.
Right? So if you're gonna lease out a $100,000 bus and you're gonna do it $100 a day, that's not under the $5,000 threshold or whatever you come up with, because it's the value of the equipment. It's the district's asset that's at risk that you need to set the threshold.
Alley Cap will insure you while they're driving the bus, but that doesn't answer the questions that Cody's talking about. That's the other thing that people are like, oh, we've got coverage. Well, maybe. Okay, question. Bus leasing, renting a forklift, borrowing a tractor. Does the term leasing include all of these three?
Yeah, so the leasing policy is gonna address anything that's, as we term the law, personal property, which if it's not fixed to the ground in real estate, it's gonna be a good, it's gonna be equipment, it's gonna be a vehicle. So this contemplates that.
Yeah. Yes, Chris, the answer is yes.
One thing this doesn't necessarily substitute for the post-prom parents informal group want to use the bus for a well-written contract, right?
Yeah,
that's the
the
other
very
thing.
next one.
So this is an authority policy. It doesn't answer the question of what terms should be in that specific lease. They're laid out in here, but again, I wouldn't call this a substitute for a contract.
Well, and the other thing is that, we got a question here, how about a free loan to our parochial schools for bus use on a trip? As the policy is written, that would run afoul of it, right? Because what it says is that the superintendent's prohibited from entering into engagement that would lease the school property at a rate that's significantly lower than the fair market value. So if a citizen can't go to Enterprise or Hertz or whoever and get a similar vehicle for free, then the school shouldn't be leasing it out for free. And if anything, make the lawyers and the policy the bad guys so that you don't have to say no to friendly faces that want the school's assets for free. But the reality is, and part of the reason the policy is that the school's giving away something, whether it's wear and tear, whether it's liability, whether it's saying yes to one person having the political cost of saying no to another. And so it needs to be driven by a policy judgment decision about how the board wants to properly use its assets, as opposed to just putting you in a tough spot as an administrator to be the person to say no all the time.
I think you could set the levels in that policies. I understand that you want to loan it for free, and I think you could set the levels in the policy such that it's functionally free. I think you could say we've determined that the fair market value for our buses is whatever, low. But you can't just give stuff away because you run away with run afoul of the Blaine Amendment, which says we can't give public funds to support private education. And it also gives away, runs afoul of the idea that you can't give taxpayer dollars away to charity. So and see this, I knew we were gonna get a bunch of these bus questions, because that's where it comes up over and over again. If you're just gonna let teammates use the bus, I think you're going to have some token exchange of value from teammates to say that you're leasing it out. And however you treat teammates, you're also gonna have to let the Devil Worshippers Club have it on the same terms, or the Pentecostal church down the road, who the Methodists all hate because they're stealing their members. Like, those are the fights we have come up because the school let teammates use the bus for free. Now, if teammates is run through your activity program, that's a different story, because you can say that's you. But if teammates is a freestanding, or like Mike Apple's question, the parochial school, this policy implicates that. You can set the levels where you want, but we think you need to get something for that, and pretend like that's fair market value.
And two things. One, if you want to do it for free or something super low, you're going to have to amend the policy, because that's going to be significantly lower than fair market value. And the second thing is that you shouldn't be giving it away for free. The district should not be giving away district assets for free. And so if the board's going to make that policy decision, that needs to be something more formalized than just a wink wink and a nod nod, and they're a friendly group, and so we're going to let the superintendent do that. If they're going to do that, let's talk about it too, because I still don't think you can give away those assets for free or subject it to wear and tear for free when it's not in the school's interest. It does nothing to help kids. So we can talk it through, but that's
does nothing to help the school kids. That's where people run afoul of it, because it's helping the Catholic kids.
Good point, Joe.
This is just like anything else with your facility use. If your board says, no, we're not gonna charge Little Kid Wrestling anything, I don't care, we'll assume all that risk, that's a discussion that you have to have, right? But this policy doesn't do anything that the law doesn't say already,
Yes.
which is why we knew when we put it in there'd be questions about it. So is the law difficult to comply with based on your current practices for a lot of schools? Probably. But we just want, again, we get the question enough, and we thought it was a good idea to at least put it in front of them.
And from a best practices standpoint, the more expensive that the equipment is, and the more ability it has to do with dismemberment and death and things like that, let's talk through those contracts and your insurance and risk management program. I mean, if you lend out somebody a $200 wheelbarrow because they're going to pour concrete in their front yard, I'm not as worried about the liability either from the property damage standpoint or hurting somebody. You're going to lease a bus out, right? You're going to want to make sure, who are the drivers? Do they have liability insurance in place? Is it enough? If the district gets brought into that lawsuit, are their $250,000 limits going to be exhausted in the first week? Or do they have the $5 million that you're going to need to get up to your tort liability? Things like that, it's worth thinking through, the more dangerous the equipment is.
Okay, anything else on leasing? Okay.
All right, next one is 3053. This one's pretty easy. This is a new policy to the extent that we moved policy 4001 into 3053. So if you flip a couple down, policy 4001 has always been our non-discrimination policy. It got put into the staff section at some point way back when a majority of the laws that we were talking about, we also did our complaint procedures differently. But anyway, that's a long way of saying we moved that into the general section because it covers a lot of people. It covers patrons attending a game, it covers staff, it covers students. So we thought our general non-discrimination policy should be in the 3000 series versus 4000. Steve will talk later. We've also amended our standard non-discrimination notice. It's what you put in your handbooks and on your website and all that stuff. But 3053 it shouldn't look any different to you. It's what 4001 used to be. So we'll talk about that again here in a second.
Now we get to the law enforcement unit policy that I was forecasting about with the threat assessment change. So again, with the new emphasis on, renewed emphasis on school safety, a lot of schools are wanting to be able to share security video and other records with law enforcement. FERPA would say that you cannot share any student record, and any student record is anything that has personally identifiable information that is maintained by the school district. That's a student record. And it says you can't share that. FERPA also says records created by a law enforcement unit are not education records maintained by the school district, they're maintained by the law enforcement unit. This is literally a function of discussing what name is on the hat that you're wearing while you're watching the video, right? The principal can be the school district disciplinarian. The principal can also be the law enforcement unit. And it all is driven by whether or not your board decides to adopt the proposed changes in this policy. So if the principal is wearing the hat that says law enforcement unit and he watches the fist fight in the hall, the principal can immediately share that with the cops without any kind of subpoena or notice to the family or even thinking about FERPA. The principal can share that immediately. If the principal wants to use that video to suspend or expel the kids that were in the fight, you must make a copy so that the law enforcement unit version of the video remains law enforcement unit. The copy now becomes part of the student record. And if somebody calls and says, I want to see a copy of the video, you say yes to the law enforcement and no to the student record, even though they're exactly the same video, right? That's the weirdness of how the law enforcement unit exception is written. But this is a way, it's a path forward for boards of education that want to be able to share way more with law enforcement, with first responders. Now, understand you take the bitter with the sweet, right? If it's a law enforcement unit, you may also have to release it to the newspaper or to the TV station because it's a public record. There's no doubt that you have to release it to the parents of the kids involved. I think that's true under either FERPA or law enforcement unit. But you may have to release that to the crazy ex-husband that wants to watch how many times his kid walks down the hallway to go to the bathroom every day. So there's implications to whether or not you want to call something an education record or a law enforcement unit record. But if you want to do it, that this policy takes you there. I also think that we're going to do some additional training on FERPA. That's I'm sort of thinking to myself while I'm talking. The changes to the law on school resource officers are going to require a crap ton of training to anybody that has an SRO in their building. And we're thinking that we're going to offer some of that training, and I think we'll include the FERPA implications and the law enforcement implications training in that training. So this is not a change I would recommend that you make lightly, but we've had a lot of schools be really committed to being able to give a login to their security video to the cops. If that's what your board wants to do, policy 3054 and the changes in it are the way forward. Chat. Do we always have to release to the law enforcement and everything they ask for if we adopt this policy? So if you adopt this policy, the law enforcement unit is defined as people that are basically within your school facility. So the law enforcement unit would be the principal or the threat assessment team, or your school resource officer could be your law enforcement unit. So then the question is, do we always have to release? It's not really a school question, then it's a law enforcement unit question. And you would not have to, but it's gonna be harder for you to draw the lines between yes and no. So the law doesn't require it, but you're gonna say no, and then the question is why, and it's gonna be hard for you to articulate why. I hope that makes sense, Josh.
When it's a public record.
When it's a public, well, we can withhold security footage from the public record statutes because deployment of the security cameras could give the school shooter. There's a way we can withhold access to the cameras from the general public, but it's harder to withhold from the cops if we identified it as a law enforcement unit record. So I like the way you're thinking, Josh, because you're starting to think about sort of the downsides that could come along with this. The initial, I think the average board member's initial response is going to be, of course, we want the cops to be able to see if there's ever a crisis. But it's also going to be tough for us to say no if they want to just monitor the hallways for drug deals. And maybe we want them to, but you're going to have to think through kind of where you want to fall on that. It's a good question. Kind of wait and see if anybody else is feverishly typing in questions. So.
And we've talked, this isn't the first time we've talked about it, it's our first policy run at it, but like the Nebraska Attorney General opinion letter, I mean, nationally, I mean, this has been a trend I think you're gonna keep hearing about and reading about, so, you know, I think it's probably a good idea to call one of us and talk through what you currently do and whether or not that's compliant with FERPA, but then whether this would help or hurt. To Josh's question, I don't necessarily think of it, I think of it more like a valve, rather than like a pick and choose kind of thing. When Karen says you take the bitter with the sweet, I think that's exactly it. because this is one way to get more information to law enforcement quicker,
Yeah.
without parent consent, right? All the things that FERPA would otherwise foist upon you in a non-emergency situation, especially. But we've been operating without it for a long time too, so we're kind of torn here on the merits of it.
And you don't have to put it on yourselves of you're either gonna share this information with law enforcement or not, right? There are other things like responding to a subpoena and things like that,
Yes.
tools that county attorneys and law enforcement have, that even if you don't have a law enforcement unit exemption, you can still get them the information if it's critical. There's also an emergency exception if you think it's an imminent threat. So don't put it on yourself as if it's one or the other. You're either gonna be friendly to law enforcement and pro safety or anti. That's not on you 100%.
One of my frustrations is that, and I like, this is not a political statement in any way, shape, or form. Our current state attorney general is pretty friendly to schools and has been someone good to work with, whatever you think of the politics, which I always want to be very careful that I'm not making any kind of political statement. But one of the things that he has done is really emphasize, oh no, Ms. John Law, you can get anything you want from the school. All you gotta do is have an adopted law enforcement policy. So you're gonna get pressure from local law enforcement to say, oh no, Doug Peterson says it's just magic sauce and you can give us anything you want. And I think that it's wise to kind of pump the brakes on that a little bit. I'm not saying yes or no, but those decisions have consequences.
And Stephen, you're right. Stephen Griswold said that, this is confusing. Should this be a conference topic at some point? The fact that you find it confusing, I think, shows you do understand it. Because it's not linear. It doesn't always make sense. So I think, yes, absolutely. I think we will be presenting on that in the future.
The problem is,
Multiple times.
the question is, can't we just give the cops access to our security cameras? The answer to that is yes. But to get there, it's like the family circus, whatever that kid's name was that went through the little Jeffy. You gotta go through all these intellectual hoops to get there. And each one of those intellectual hoops has kind of a consequence.
The Family Circus was a cartoon back before your time.
Sitting next to the cartoon.
Oh, okay. The other thing we at least talked about was maybe just having this be a freestanding webinar that we do, but we're gonna do some additional training. Some schools, the boards know that they want this, that they've had situations in town where they don't care what the privacy cost is, they want the cops to have to film. Others are kind of more reluctant. Again, if I was on a board, I'm not sure how I would vote on this one. I'd have to think about my community situation. And the fact that you have a news, like a TV news station in town, that would also weigh heavily in my decision making as if I was a board member about whether or not I wanted it to be on KBT. But all of us, in the digital age, could get a request for security footage from the TV station. So there's that.
Any other questions about that? Yeah, you shoot them in later if you think of it too. We'll keep
Yeah, and
responding,
if you ask a question off topic, I might text you back, and then I get snotty texts from Dennis Ship that I'm texting on camera. So, but I'll answer everybody's text but Dennis's.
So the next one, if you're tracking along in the memo, is 4001. We already talked about that. That's been moved to the 3000 series. After that is 4048, the Assessment Administration and Security. Props to Chris Brasowski for catching this, but we had references to NISA testing, basically. It didn't say NISA, but it said the right words for Nebraska State Accountability. So that was not confused with the NSCAS testing now, we've just changed the wording of the policy. Nothing substantive, at least we don't think it's anything substantive. For what it's worth, it probably wouldn't have made any difference, but we wanted to change that. Yeah, you're next, 452.
This is an amendment to the job references policy. ESSA includes, those of you that are old like me, remember that when ESSA was becoming effective, it was this weird rolling implementation date. Like some parts of it were immediately effective and some were 18 months and some were 22 months. And one of the requirements of ESSA is that any employee or former employee who you have probable cause to believe has been engaged in sexual impropriety with a minor, you're not allowed to help that person get their next job. And in all the rolling in effectiveness of ESSA, a lot of schools have not put a policy into their book on that issue. And so the Department of Ed issued a Dear Colleague letter last summer. I've got a link to it that says, hey, this part of ESSA is now effective. You're supposed to have this policy on the books. So we've written this in the most the shortest way possible. This is one of those policies that we spend a long time on to try to carve it down to make it short and pithy. Bottom line, if you have, and the definition is probable, if you think it's probable that an former employee is engaged in sexual misconduct with a minor, you can't write that person a letter of recommendation. You cannot give them assistance in finding another job. Hopefully, we all decided that if you've got a situation like this, you've contacted your school attorney to get that person kicked out the door, and we'll be able to highlight this requirement to you. But the other thing I want to point out about this one is ESSA applies not just to administrators, but to any employee of a school district. So if I'm a kindergarten teacher and I just don't believe it's true that my co-teacher could have had sex with that high school boy, and I want to write a letter of recommendation for my co-teacher, I am violating this policy and violating federal law. So it's a little point of training that you're going to want to do with your staff as you start in services for 1920 as well.
I got a question going back to the law enforcement unit stuff, and this is a key point. This is what Cody was saying. Is this law enforcement unit designation required if you want law enforcement to have access during a crisis? No, right? So the law enforcement unit is something completely separate and apart from the list of exemptions to parental consent in purpose. So a crisis situation, responding to a subpoena, even if you don't adopt a law enforcement unit series of policy changes we're suggesting, or at least not now, that doesn't mean the first day of school that you've got a crisis situation, you can't share like you always have with law enforcement when there's an ongoing crisis situation.
But what that means is, and this is what the network administrators group that I talk to and the other tech nerds that I deal with, they don't like having it only be in a crisis situation, because that means you have to find one of the nerds to throw the switch to give law enforcement access to the cameras. I think that's fine. That's what we've done to date. But the network administrators are nervous that somehow they're not going to be able to throw the switch quick enough, or you're going to have to wake them up out of a sound sleep at midnight to give them access. So yes, there's nothing that prevents you from doing that if there's a crisis. The Virginia Tech exceptions absolutely would let you disclose that information in a crisis, but you're going to have to find someone to actually push the buttons. And a lot of you have that access now, building level on your phone. So I don't think it's that big a deal, but the NOC group doesn't like that option. They want to have it be all or nothing. Next.
Yep.
Oh, this is one of my hobby horses. I'm on this committee dealing with improving the educational outcomes for poor quality youth. And it's so frustrating to see what happens to kids that get put in foster care and get jerked around from home to home and school district to school district. In an attempt, so let me give you the example. North Platte High School has block scheduling. DHHS thinks nothing of pulling a kid out of North Platte, sticking him in Hershey for 6 weeks, and then sticking him back in North Platte. Problem is, the classes don't connect at all because North Platte has a block schedule, so they're taking half the number of classes that kids in Hershey are taking. A kid that gets moved out of North Platte into a neighboring school and then back, his or her chances of graduating high school on time with their cadre going through the regular curriculum are like less than 20%, I think is what the data shows. What we end up doing is putting that kid on OdysseyWare so that they can follow through with their cadre. That makes me crazy. So this committee that I'm on created this document called the Education Court Report. And what it's designed to do is to force a caseworker to ask some questions about the educational situation of the kid and of the two schools, and to get that information before they make an educational decision. The problem is nobody's using the Education Court Report, or the judges that require it are mostly in the Omaha Metro. And even then, we've discovered that DHHS's guidelines tell them that they fill out the Education Court Report within 6 weeks or 45 days of the kid having their placement changed. Well, that's almost a whole quarter that the caseworkers just made this decision without any information. So here's what 5002 is designed to do. When a student who is court involved is placed into your school, you are now going to ask, has there been an Education Court Report filled out? May I see it? If the caseworker says, I don't know what you're talking about, you have access to the form now. You can say, here's the form. It's what the Supreme Court Committee says you're supposed to fill out.
Can I help you complete it?
Yeah, and if they say they haven't completed it, that's right. The policy says, Cody's right, that we will then offer to assist them in completing it. The reason I'm hesitating is this policy walks right up to the line of saying we won't let the kid in unless you filled out the Education Court Report. But please notice that it doesn't say that the kid can't come in unless they've completed it, because I don't think we can stop them from being home. So, it's a way for us to try to get HHS to do their job, and probation's supposed to be filling it out too. To try to get, probation and DHHS to do their job in terms of asking these questions about the kid's educational situation before they just willy-nilly uproot them from one school and drop them in another. How would this apply to group home kids? Josh, I also would ask this of caseworkers when a kid's been put into a group home. The education core report is supposed to apply to all foster or all court-involved kids, not just foster family home kids. But I can tell you that I know what's gonna happen when you ask. They're gonna say they haven't filled it out and they're going to group home anyway, so screw you. But at least asking the question, I'm hoping to move the ball towards. And again, it's not that we're trying not to serve these kids, it's that the data is overwhelming. That court-involved kids change schools like 7 times more than non-court involved kids. And they only graduate high school at like a 30% rate with their age cadre in their original curriculum. So being court involved should not mean you automatically either become a high school dropout or graduate high school a year late. But by allowing the system to not consider kids' educational needs, that's what's happening. So I feel really strongly about this. It's just as easy for us really to shoot and roll them, stick them on Play-Doh or Odyssey-ware, who cares? But I don't think that's the right thing to do. So
This feels similar to when nobody would give you the best interest determination letter. And then so it took hounding for years, and now all of a sudden they have that best interest letter.
But that best interest letter, they've done literally nothing to see what the kids.
Exactly.
We had one where the only thing the kid liked was soccer. So they put him in a school that didn't have soccer. That just makes it, and then nobody bothered to ask.
They put them in the school where they had an available bus. But that
They were in a
frustration.
soccer program within 25 miles of driving distance, so they could have driven that. Anyway, so that's the point, to at least try to make the system start asking those questions.
Well, we've got her fired up.
Okay, student records. This one's kind of fun. Just that I was sitting at the National Council of School Attorneys Conference and.
Well, fun is a relative.
It's fun for me because I'm a nerd. The National Director of the Privacy Technical Systems Center, which is the U.S. Department of Education Privacy FERPA guy, said that the ACT has these surveys that are included at the beginning of every ACT. And I hadn't really thought about it because I know that those questions are voluntary, but he pointed out that, one, we're disclosing, the ACT gets the testing data about all of our kids, and then two, ACT releases that information to, like, colleges and State Department of Ed, whatever. So 5016, all this policy change says is that we don't have a choice in whether or not we give the ACT. The State Department of Ed has decided for us that we're gonna give it, and we're gonna hide behind whatever that contract says about redisclosure of information. It says what it says, we don't have any control over that. So that's what 5016 says.
That's what the first change to 5016 says.
And then there's something else on surveys that we'll get to in a second. But
It does either way. But so that's the first part, the first paragraph. You'll see then there's another part that talks about designating your school officials. Under FERPA, you can allow access to even FERPA protected records to anybody who is a school official. And you can designate those folks in addition to identifying them after the fact if they have a legitimate educational purpose. So we've simply cleaned that up a little bit and also added your insurance providers, because you clearly got state law authority to buy insurance, but you can't share the information needed to trigger your policy coverage. Doesn't do you a lot of good. So I get the call, we got sued on X or Y thing. Can I give this information about the student to ALICAP, who's the basis of the lawsuit? This would allow you to do that. Now ALICAP, and I think they know this, is covered by the not redisclosing that information. But this at least makes clear then that you can provide to those folks.
And when someone's designated as a school official for purposes of the information that goes out, you have to exercise enough control over them for purposes of that information, like they're an employee. So for ALICAP, it's not just once they're there, they can do everything they want with it. And ALICAP's gonna know, but other people that are designated school officials, you also have to say, take care of this, don't redisclose it, I have control over it. If I ask it back, you have to return it. If I ask you to destroy it, the way that you could tell a teacher to do that, that school official also has to be under the same control for purpose.
You'll notice our list is pretty slim for who we specifically designate for that purpose.
And we're gonna need to, one of our projects this summer is to go through that interlocal that you have with ALICAP to make sure that it includes all of that required stuff into that interlocal so we can point to it. But for now, adding insurance carriers, school officials makes sense. There's another change to 5016 if your district decides to have this law enforcement unit exception that we've been talking about. You can see that it kind of trails through several different policies. So if your board is one that wants to have a law enforcement unit designated, you should make that change. And so this one is weird because there's 2 required and 1 optional change. And then while I'm talking about ACT, 5017 is the survey question. The survey is voluntary when you sit down and take it when you're taking the ACT. But remember that under the PPRA, it is parents who get to decide if a kid takes a survey or not students. So when the high school junior is sitting there at the ACT testing time and the form says only fill the survey out if you want to, you're not really making it optional to the person who has the ability to make that call. So you're going to have to put into your student handbook, and our handbook updates, if those of you that use our handbooks will get that when we get the updates, the handbooks out. But you're going to have to put into your handbook that students are surveyed about, what do they call it, super sensitive issues, because they ask about income and some stuff like that. You're going to say that they are surveyed when they're juniors, when they take the ACT. You're going to have to give parents the ability to review those ACT survey questions. And you're going to have to give parents the authority to say, my kid is not filling that survey out. And then if the parent says that, when the kid opens up the ACT testing booklet and it has the survey questions, you're going to have to walk over and say, no, Steve, your mom says you can't fill that out. I know that's stupid. I know they're high school juniors, but that's what compliance with FERPA and the PPRA is going to require.
We got that later in the memo, like a more of a recitation of exactly what Karen's talking about in the other issues section after we get there. So we'll probably get back to it, but.
Yeah. And we have a link to that, the guidance document from ETAC in the memo. So.
All right, 5017, routine directory information. Almost 20 years ago now, we had the No Child Left Behind Act that was passed, and it included a provision giving equal access to high schools and high school students for military recruiters. They were being shut out by some schools across the country. So that law was changed. The state law has now adopted a similar provision, but it's different enough that we had to revise our policy, have a couple of different requirements, and they use some different wording than the federal act did. So we revised that to make it clear that the recruiters will have the same access that others do to high school and high school students. That change is required.
5222, option A, I'm going to go through this fairly quickly. A couple of years back, we added 2 options basically for interfacing with law enforcement, DHHS, and those folks. Option A is friendlier with them to the extent that when you call because you've got a report that somebody has drugs in their backpack, option A allows those law enforcement that you summon to sit down with the kid in the school and ask questions if they want to. And they've got their own whole set of constitutional considerations. But option A says the school is going to allow that. Option B says the school is not going to allow that. But one of the questions we got most frequently about option A, which is the one that most schools are using, because your local law enforcement is going to be mad when you call them based on a report of drugs in a backpack and then tell them they can't do anything about it inside of the school. So a lot of schools choose option A because it's friendlier with local law enforcement, especially when you summon them. But what it has said is, and there's a lot of national thought out there about this, but basically that you're in loco parentis, right, when a student is at school. And so our policy had said that when we allow law enforcement to come in to interview a student, if we've called them, we, the school, will have somebody like a principal sit in our capacity as in loco parentis. And if we think that interrogation or line of questioning is going too far, that we'll say something and stop the whole thing if we haven't been able to reach the parent, right? So first we try to reach the parent to come in. If they can't be there and the cop insists on moving forward, we'll put a principal in that room. We talked about it for a long time, actually, and Steve's right. The question is, what type of capital P parent do you want to be when you're in loco parentis in those situations?
I literally, just after we moved to this policy, I went home and told my kids, if a police officer stops you, what do you say? And my kids have it drilled in their heads. Am I free to go? Am I under arrest? I want to talk to a lawyer. Because I'm that parent, I don't want John Law talking to my kid without me there under any circumstances. So the feelings run high about this.
Yeah, absolutely. So we've changed the policy basically to say that if we have a principal in the room with that student, no longer are we gonna force that on our principals under option A, but they can be there if their reason for being there is to serve a school purpose, not to act as a parent. So there's an allegation of sexual abuse, and the law enforcement officer wants to come in and interview both the alleged assailant and the victim. We may have a principal that wants to sit in on both of those for student discipline purposes and also to not re-victimize the person who was allegedly assaulted by subjecting him or her to a second interview from the school side. So we changed that basically to make it so that we're not going to make promises to parents that we will sit in Karen's place when she has these strong feelings. Yeah. So it's not wrong if you are doing that, as the policy was written and saying, we're going to have a principal in there who's going to put the brakes on the whole thing if they think it's going too far. You can still have that as a policy, but basically what we've done is change option A to make it a little less onerous on the school to fulfill that role. So there's no easy way to explain it other than that, but if you will have made a decision about policy A or policy B under 5022. So you should review that. And if you selected option A, you should look at whether you're actually doing that part of the middle of it that talks about having a principal present in every investigation, and consider whether you want to keep doing that or whether you want to change it to the slimmed down version of the same thing.
I'd also mark this policy with a star because if and when the proposed Title IX regulations come out, that procedure that you have to do for the parallel tracks of student discipline, working with law enforcement, Title IX investigation, who wears what hat, may affect who's properly in the room for purposes of this policy. So
Absolutely.
Question, what happens if the issue, if the issue is against parents for DHHS, that's a completely different deal. You are obligated to give them access to the student. Again, I know, oh gosh, I know what your question really is. You wanna have the elementary guidance counselor in when the kid is interviewed because it's nicer to the kid. Again, Steve and I have strong feelings that, like, that's not our job.
Again, it goes back to the local parentis best interest of the kids. I mean, if the issue is you want a council president that makes the kid more comfortable, I think you do it, period. I think it's about making the kid comfortable in that situation.
But you cannot, tell the parents if that's what's happening. You're prohibited from contacting the parents if that allegation is for any abuse or neglect, regardless of whether it's against the parent or by it. That's how the statute.
And DHHS should have a piece of paper at that point.
Yes.
Just like if law enforcement comes in with an arrest warrant and says, I'm taking that kid, I don't care if you have option B that says you're not going to conduct any of your business in our school, they're going to walk in and grab that kid, right? So these policies are intended to address those circumstances, at least in the part that we're talking about amending, where they haven't come in with a lawful order saying what they're going to.
And the difficulty with this policy, either option A or option B, is we could have options C.
Absolutely.
Almost every single paragraph of this policy could be changed, depending on how you want to do it and what you actually do. So just keep that in mind. If you don't like the options as they're written, you can have so many different variations of this policy.
And remember, this
we
is a
can
service,
accommodate.
yeah, so it doesn't cost you anything more to go through it. I would much rather, I get nervous when we have these policies that I don't think necessarily exactly track with what your actual practice is. So I'd rather have you, please call us and get your money's worth out of the service, but also make sure that your policy actually describes what your practice is. So.
All right, policy 53, student discipline. We made a few changes to this. We added a couple of provisions. They prohibit possession, use, handling, or transmission of a look-alike weapon. We've had how many of those this year and last year?
Weird.
And then the simulation of possessing weapons where they stick their finger inside their sweatshirt and say they have a gun, or they put a remote control in there and say it's a weapon. That is now specifically covered. The other thing we've done, like we talked about earlier, we added the electronic nicotine delivery system to the list of things that are on there. We also had gotten a little over aggressive when using the term state law instead of Nebraska criminal code to track when we have to report things to the county attorney or the local law enforcement. And so we've dialed that back a little bit to make clear that it's only Nebraska criminal code violations that we have to report for.
One thing that I do want to add to that, the change in the statute to where it used to call it an alternative nicotine product, right? In my mind, when I think of a Juul, I think of the device that allows you to ingest that, and I think of the packet, right? You've all had kids juuling in your school, and if you think you haven't, then you just haven't caught them. So if the kid has the little packet, that in my mind has always been the alternative nicotine product. And you'll notice with this legislation and also the change in our handbook, they've actually now made the dispensing device part of it, right? The change to talking about it in terms of the device that can dispense the nicotine in that packet. So we got the call all the time, Bobby, we see they have a Juul, but we don't know if that's just fruit water or it has nicotine. Will local law enforcement test it? No. The change in this says now that the possession of that little device is more legally significant. It used to be, we can make it a school rule not to possess it, but it's not necessarily unlawful to possess a Juul that didn't have the packet. Now I think we've got more authority under the law. I think candidly, that was part of why it was changed, is schools saying, well, we see they have a Juul, we don't know what the juice is in that little packet, so we're not sure what we can do about it. This should make that clear now. So if your principals aren't in the room with you, if you're a superintendent, tell them, right? This is part of the handbook change too, that if you use our handbooks or whether you do or not, you're gonna wanna make to your form handbooks as well.
There's a general question.
Sorry, my contact just turned, so I can't read that, so what's the answer?
With this new change, do we continue to contact police even if they don't do anything about it?
So I think that that's part of that discussion you should have with the county attorney at the beginning of the year about what violations of Nebraska law or the Nebraska criminal code they want you to report, which ones they want to leave to you. There's probably a hierarchy and it's going to depend on your jurisdiction, but I would add this to the list of, if you want to hear about it, do you not? And then if you've documented it, then it's somewhat addressed your obligation to report everything because the county attorney said, no, we don't want everything below this threshold.
So Josh, if you reached out to the Seward County attorney and showed them the end of our student discipline policy, we've actually taken a crack at minimizing some of the stuff that you might otherwise have to report. If in your mind, you think that it can be addressed appropriately, like sort of a society at large thing. A kid throws a pencil at somebody else, yes, that's technically an assault, but they really want called on that. So I think what we've already tried to do, the default in your student discipline policy, if you didn't change it last year, is that scaled back approach already. So if your county attorney has not looked at that, I would follow up again and say, please look at this, because this means we might not report everything under the criminal code. But you may have a county attorney who says, no, I want you to report everything anyway, and then, yeah, there's nothing you can do to change that. If they want you to report everything, you have to report it. That's how the law was changed last year.
So the answer is, with the new change, it's one of the things you should specifically ask the county attorney about. We do that annual check in.
And if they ignore you, well, okay.
We do that all the time.
So the next section is policy on student fees. We made a change to update the prevalence of technological devices in schools. In general, you're prohibited from charging a student fee if using the device is required to access the curriculum. So if teacher says, go home tonight and read these 20 pages on your Chromebook at home, then you're probably not going to be able to charge a fee related to students accessing that Chromebook because it's part of the curriculum, just like you wouldn't charge a book fee for someone to take a home history book ages ago when I went to school. Now, there are some narrow exceptions to where you can get to the fees if certain conditions are met. For example, if there is no real homework and if students are really only taking home the device as a convenience to them, and if there's enough time after school to use that technology or before school to access the curriculum, they don't have to do it at home. We think you can, in those narrow circumstances, charge a fee to be able for the students to be able to have the convenience. If you have them deposit a sum with you, $25, $50, whatever it is, as a damage deposit, that's going to go against future costs incurred based on damaging the device, we think you can collect that deposit, but I think if at the end of it, that device is pristine, you have to return it. I think at the end of the school year, you probably have to roll it over as a credit towards the device on the next year. And so we've tried to, one, address it, and two, provide some narrow circumstances if that's what your practice is, in a way that you can comply with the law. But these narrow exceptions are all under the heading of you can't charge a fee so that students access curriculum. And frankly, there are way more many districts out there doing it on the wrong side of the law right now. So I think as you're going through these other policies, it's worth thinking about what your
Wait a minute, so you're not saying I can't charge a technology.
Well, who's my client? Because the answer is independent.
You'll see how we haze at KSP, right? When I was a new attorney, it's like, wow, we wanted to address this transgender issue. I'm sure we not. Now for coding, we give them all this stuff about leasing your bus to the Catholic school and not charging technology fees. But the short answer is, I've seen your handbooks. You all have a $25 technology fee, and that's all it says, or you have to buy the insurance. I don't know how else to say it other than that's unlawful, if not done one of a very narrow number of ways. we've talked about it, we've presented on it
The
recently.
department is on this, like, they get complaints from parents, I get calls from Brian Halsted, like, and what's super embarrassing is if we're at your laptop rollout doing digital citizenship, and then at the end they say, okay, everybody come over here with your check for your $50 technology fee, and then once you give us that, we'll give you your computer, and so, Cody's right, it can be a damage deposit, I think that's, but if it's a damage deposit, they get it back. That this cannot be the way you fund the extra expense for a staff person to have 8.5 to manage that thing or to fix it or whatever, unless it's for true damages. It can't. You didn't charge a book fee to pay for buying new English books in 3 years. You can't charge a technology fee to pay for new computers.
And good luck selling it to your board that we should spend all this money on one-to-one devices that never have to go home. Right, I mean, that's part of the, there are schools that do it
There's a good
that
minority
way.
of schools that
Sure.
are doing that and doing it with fidelity, but it is tough.
And I think it's worth actually having a discussion with your insurance company, whether it's AliCap or EMC or your local agent about, is there a way to add the $20,000 in one-to-one devices out there to the $800,000 in desks and computers and servers you already have covered by your property? Is there a way to have those deductibles not be on each device, but on an annual basis? I mean, I think there's some creative ways where you can manage the risk because it's not accidental and it's not something you're not planning for. So I think it's worth having those discussions.
What if we give them the device after 4 years of charging a minimal fee?
Oh, good, let's violate 2 laws in one. Let's charge them a book fee and then give away public property. That makes me so happy.
What if we make them buy it and we don't give it to them until years of making them pay for it?
So we love you all because this is why you're creative. And Apple, I appreciate the question. There are schools that have that $25, and if at the end you want it, we'll give it to you. So functionally, each of your $25 is to buy it. I've seen schools that do a credit toward the cost of it with good attendance, or a credit toward the cost of it by getting good grades. Let's put it this way. There are ways that you can be creative with this policy, which may ultimately allow you to sell them that device at the end. Even in some cases, to give it to them if you structured it the right way, but we just don't have a ton of authority, in fact, any, since we changed that statute, 79.526 a few years back, to be able to provide things to students for educational and extracurricular purposes. So if you want to be on the cutting edge of, Apple, if you want to be on the cutting edge and have a policy that says, we can do this, here's how we're gonna structure this, you're gonna pay $25, and if you have less than, fewer than 10 absences a year, we'll give it to you at the end. There may be a way to do that, but that is not gonna be in this policy, and that's gonna be a one-off, basically, kind of contract you're gonna have with each of those kids, because that's what it is, right? It's a contract to them. That's the only way you're gonna be able to sell it to the state auditor.
And you're gonna have to be ready for the kid that goes, no, I don't want to do that in 4 years. I just don't want to pay anything now.
Yeah, there are a growing number of parents, and it's not necessarily parents that don't have the ability to pay. It's parents, it's the pain in the ass parents that are like, no, you can't make me charge them. You can't make me pay. And when they call Brian Halsted at the department, he says, that's right. Josh, can you charge the full price for a damaged laptop? Yeah, I think you can. Just like you could charge the full price for a damaged history book. If the kid dropped it in, the bathtub while he was doing it.
The difference that Cody pointed out, if you go read the Student Fees Act, and if you haven't in a while, you should, because this is you have to have the waiver for free reduced kids for extracurricular, that all that is part of the Student Fees Act. It clearly says you can charge a fee for damage to school property, yes, but it implies the damage has to occur beforehand, right? So that's why we're a little risk averse in saying, well, but it's maybe the only way you can do it. If you call the $25 at the beginning of the year a deposit against that damage and give it back, then arguably at least you wouldn't have kept it unless they did damage it, but you could have gone after it. So it's still a risk to do it that way, but the short answer is yes. If you don't charge anything for insurance or for security deposit, and you walk and see a kid slam it down in the middle of the hallway and that thing costs $400, you can take that family to small claims court and sue them for that $400. That's clearly authorized in the Student Fees Act. It's the getting it up front part that is the fee that makes us nervous.
And there's where's the book? There's a book fee.
Before my time, back in your day.
There is a case that says in Nebraska you cannot charge a book fee. There were schools that were charging like everybody has to pay a $20 book fee. That is unlawful. I do not see how we can distinguish between, especially if we're flipping or we have our OER resources on the computer, I don't see how you distinguish that from a book fee. I don't. So.
All right, we're making progress here, believe it or not. We got half an hour to get through this.
So these are parents that, well, this goes with the Alexa smart speaker EcoSense.
We're on to 5063.
Yeah, we're on 5063. Kids don't have a right to have those in the classroom, so this policy makes clear that they have to have permission before they bring those to school and turn them on. It also says that you can't have anything that is a recording device unless it's like a public performance, like a basketball game or a choir concert. Even the choir concert poses some copyright problems. So it's just an update to address the smart speaker trend that kids are bringing stuff to school. That's it.
All right, now we're onto the forms. So we're on what we see as page 15 here, but now we're out of the policies and going to talk about forms and a couple other kind of non-policy but hot button issues, and pretty close to done. So if you have questions that you haven't gotten to, send them in.
And we'll unmute you all at the end, so if you don't want to type questions and you want to shout them out, we'll give you a chance to do that.
All right, the first one is a revision of the notice of non-discrimination. What had happened over the years, and this is our fault. We would have various complaints filed against our schools, and Office of Civil Rights would come out and investigate, and they'd say, we want to see your notice of non-discrimination, and they would give it their blessing, and so we would go, oh, well, that's our most recently approved version from OCR, let's use that. And so that found its way into some handbooks and some policies, so we ended up having different versions all over the place. And so what we ended up doing is we went to their website, they have a sample or model version of that notice of non-discrimination. We've taken that and we're using that. I will tell you, I like it less than the ones that they have approved previously. I thought the other ones were better. But this way, there's no question we were complying with their requirements using exactly what they put out. And so that's what we've done. And so this is the thing you would put on your website, in your handbooks, and anywhere else if you're going to put the notice of non-discrimination. This is different than the notice of non-discrimination for your food programs. That one is slightly different. And that one hasn't changed. That's been the same forever. So the one you've been using here is fine. Put that in your handbook, you put that on your website, and you should be good.
So the next one we have is a form in the 3000 section for when people want to borrow your facilities and they have a general facility use application. We basically tweak to the insurance limits that you're requiring in there for someone to have access to those facilities to $5 million per occurrence. This is consistent with the Nebraska Tort Claims Act, which allows claims up to $5 million for all claims arising out of a single occurrence. So we want to make sure that you don't have a gap between the group using your facility and when your tort claims liability kicks in. That maybe sounds pretty high, but what I'd say is if it's a one-day event or eight Saturdays a year, things like that, there should be some relatively inexpensive insurance coverage that those groups can get. I talked to your local agent if you want to be able to just know what's out there before if you're imposing that, and it also requires you to be named as an additional insured. That can also be, I'm comfortable with it from a standpoint if someone has $1 million of general liability coverage and another $4 million umbrella limits to get to the $5 million, you can do that too as well, just as long as you have up to your tort claims liability.
This is part and parcel of the conversation we have all the time when we amend our facility use policy. That's not being amended. This is just a catch by Cody saying we had a gap between, well, the way that the statute talks about it is not as clear as we would like it from the insurance side of it. So if you have any questions about that, email Cody.
Yeah, and actually just as an aside, we can talk through all that risk management stuff because policies talk about two numbers and the tort claims liability statute talks about two numbers and it's 1 in 5 and 1 in 5. But you know, insurance policy, you have a $1 million per occurrence limit and $5 million aggregate. The $5 million is, you can have 5 $1 million claims over the course of the year. But in the tort claims liability, if you have a bad bus accident and 20 kids are injured, they're gonna get up to $5 million total for all those claims. So if you have that accident, you have the $1 million per occurrence limit, you're gonna have a $4 million gap between when the insurance stops and when your liability stops. So that's just something to be aware of when you're doing all of your risk management.
All right, the next one is the veterans preference. I called it the not hiring letter, so I didn't know how else to say it, but essentially the veterans preference law has been out for several years on the books now. And so in the form application that you use, you should have veterans preference wording in there. Every job advertisement that you post should say that this position is subject to veterans preference. That's probably the biggest compliance issue that sits out there now. If you go on to Teach Nebraska and you look at all the teacher postings, maybe 10% actually say this job is subject to a veterans preference, but every job posting for a public school, whether it's a part-time bus driver or a superintendent, every job posting should say that this is subject to a veterans preference. So this is somebody who has seen that posting, has applied, you've looked and in theory, at least accurately apply the veterans preference law, which says they get an additional 5% up to 10% of their disabled veteran for any objective applicant scoring system you use, or if two applicants are otherwise equal, you give the job to the veteran, as that's defined, and it can include a spouse and all that. But then if you don't hire that person that's given you the DD form and all the stuff they're required to do, the law has always required you to notify that person that they're not being hired. So some of you make a call to everybody that's applied that you're not hiring as a way of saying, gee, thanks, look for us next time. Then that may be sufficient, but what gets left out is the requirement under the notice statute and the veterans preference laws that says that you provide them not only notice that they haven't been hired, but also any appeal rights. So you're sending them a letter that functionally says you have no appeal rights, which is strange, but there's no obligation to have an appeal process, but you have to let them know that, right? So they might be able to contact the Department of Labor and file a complaint against you, but most schools, at least those schools that we work with, has an appeal process if you're a veteran who isn't selected for hiring. But so this letter can be used to be sent to send out to any of those veterans that meet all the requirements to seek the preference, but you don't end up hiring.
So there's a question about
Yeah, so the answer, we got the question of, does the general use facility application include parents renting the lunchroom for Christmas or small kids basketball using the gym? I'm gonna sidestep the First Amendment problem for a second and just say, yes, in general, if you are requiring people to meet certain requirements in order to access the school facilities, we recommend, if you're gonna require insurance, that it be sufficient for the tort claim limits. That's by far the most prudent, most lawyerly, most risk-averse thing to do. Now, if the board makes a judgment that it's gonna let anybody use the facilities and it's just comfortable adopting that liability and won't be frustrated later when the school or its insurance company writes a big check to satisfy a judgment, that's a policy decision for the board to make. But from our perspective, if you're gonna plan for it and require that insurance, it should at least be up to those limits. You don't have to, it's more of a prudence thing. Parents renting the lunchroom for Christmas, I think that's an established by cost problem, and you wanna make sure that if you're doing that, you also are revenue to the local citizens for the worship state, because you can't discriminate against viewpoints in terms of providing access to those facilities, unless our First Amendment exit.
No, that's exactly right. Mark's question is one we get all the time, which is you have to read the application and the insurance requirements and everything in the application at the same time you're reading policy 3014 and specifically section 7 and 8, which talk about whether you're going to require insurance or let people to charge a fee. So there are situations when you can agree to waive that, which raise the First Amendment implications that Cody talked about, but we've got flexibility. Adopting this change to the application doesn't mean now that Little Kid Wrestling has to buy the insurance. You need to read it in light of what's already authorized for you to waive those requirements in policy 34.
And you can say, we're not gonna require insurance at all, or we're gonna require the 1 million, and off chance we have a $3 million claim, we'll self-insure for that $2 million gap. I mean, those are all legally sufficient responses. They're not necessarily the best from a risk management.
Let's see, okay, that didn't.
All right, special education procedures. Every year, the federal government sends out a little checklist to NDE and says you need to, when you're doing your audits of the special education programs for schools, here's the things you need to look for, here's the policies and procedures you need to look for. Every year it seems to change for reasons that are unknown because the laws haven't changed, but that checklist certainly does. And so I finally sat down, went through all of our procedures. It now includes everything they've ever asked for, and some things they haven't yet, and probably should be asking for. And so that was revised back in February. Many of you have already received these because you were going through the audits at the time, and so we revised these to get you through there. But the rest of you, if you haven't adopted these or approved these, you should probably do that now. And like I said, it includes everything the feds have asked for, everything the states have asked for, and I think a few things that are in federal regulations that they're not asking for, but probably should.
Nick's other issues, this is just the PPRA ACT survey stuff that I got excited about and talked about before, so we've already talked about this, I'm not gonna regurgitate it again.
So we're in the other issues part, we're now flipping to what we see as page 18, and then comments on policy 5057, the Title I parent family engagement. All I have to say about that is we had some schools who were told by NDE that their policies and sample parent-student school compact were not compliant. If you're a district-wide title program, we talked to NDE and we figured out that that's not true, that our policy is sufficient. So if you have our most recent policy 5057 and our updated parent-student compact, and NDE tells you any different than they're okay, let us know. It's probably just a communication issue, and I think we've gotten that ironed out. We did update that the school parent-student compact. So for those of you that have, that even know what I'm talking about, have been using it, you're supposed to have that compact, and forever it said that it had to be signed by the school, by the parent, and by the student. It no longer has to be signed. So you should have it as part of your forms, but if you're somebody who's been tracking down every parent, if you're a district-wide title program that qualifies and has been asking for signature, you don't have to do
I think will make your life easier.
Steve on a reminder.
6036, yeah, last year we put together this policy on reading intervention instruction. The legislature last year passed this new rule. Everybody's got to be reading at grade level by grade 3. In any event, we put it out last year. It's not required to be put in place until this year, so if you didn't adopt it last year, it's just a reminder to adopt it. NDE was authorized but not required to put out rules and regulations for this act. They have not, but there are a couple of hyperlinks that you might want to visit. I would if I was you. One is the Nebraska Reads program. There's a lot of great resources and information about this whole concept. And there's also, although they didn't do rules and regulations, there is a list to take a look at there. And I found them to be, they do go a bit further than what's in the statutes. So I would strongly encourage you to go ahead and read those. They're pretty short. But if you haven't adopted 6036, please do so before the beginning of the school year.
Yeah, and you'll notice this wasn't included in the packet of policies we sent out because we sent it out last year. But you have to have that. It was optional last year because the law didn't actually take effect until the beginning of this school year. So it is possible that you skipped it last year and you don't see it in the packet this year.
That doesn't go through and only adopted required.
Right. Yeah. So this is now where we put required here, but we didn't include it. You should already have that one. If you're a full subscriber and don't have it, just shoot one of us an email, or it's on the website in the policy service stuff, or in the 2018. Okay, the Fair Credit Reporting Act and background checks. There's a lot we can get into here. Let me say this: the federal government agency, the FTC, that's responsible for managing the Fair Credit Reporting Act, along with the court in California, did some stuff over the last year, which required folks like OneSource and other background check companies to do things like their notice to the applicants that they're getting a background check, what they can do with it, how they can contest it. All that stuff has always existed. We put this in there because OneSource, to their credit, said, hey, in light of these changes, we've updated our standard disclosures. You should check with your school district lawyer and make sure that this is compliant, because the obligation is not on OneSource. The obligation is on your school if you use OneSource to run third-party background checks. So we reviewed what OneSource put out, at least at one point in the middle of the year. They've always been really good to work with. I have no doubt that what they're helping you put out is probably legally compliant. We wanted to raise this because all of your good, well-intended business officials, got a SHRM email that said, make sure your disclosures are compliant, which has probably already been part of the service that OneSource has provided. So if you don't know what I'm talking about, but if you run third-party background checks, reach out to one of us. But if you use one of the reputable ones, especially somebody like OneSource that's even housed here in Nebraska, they probably got you covered. But just so you know, that did change.
LB 103 is one of those laws that just make me laugh, because people apparently did not realize that if their property values went up, their taxes were going to go up and the school would end up raising more money. It's just a shock to me that they didn't know this. And so LB 103 says that if a school district's total tax dollar ask is going to increase, whether that's by virtue of property values going up or by the levy going up, there's an additional hearing and notice that has to go out. I think this is going to be basically invisible to most of you. I think it's going to just be part of your budgeting process superintendents, I believe, will end up having to send out an additional notice, and you'll have to have something called a hearing, where people have a chance to talk, which they already do under the Budget Act. So I don't think this is going to change your, processes enormously. Both the state auditor and the Department of Education here in Nebraska, are gonna release guidance and forms, and we stopped Bryce on Friday, we should have asked him, but I know that they'll have stuff out for you. So I don't think there's anything that you have to do about it right now. It did get, a flurry of news coverage when it was enacted because it was sort of the governor declaring victory on tax relief. But it's not any limitation on the ability to increase taxes, as property values go up. It's just an additional notice process. So keep an eye out for it. We don't have any policy change. Don't think there's anything you can do about it right now. Be aware that as you're doing your budget hearings in September, you may have to have these additional.
LB 281, no policy change required, but you are now required to post the child abuse hotline number. You either need to do that in a clearly visible location in a public area of the school, both in English and in Spanish, or you're gonna be able to post a link to that sign or the poster on your website. NDE has been authorized to commission a poster of some sort, so I suspect that will be coming shortly. But either option, post it in the school, put it on the website, or, hey, here's a crazy idea, do both. But that's a new requirement that will kick in for this school.
Because we all know that if we just called the hotline more, DHHS would get right on. Sorry, that was not nice.
Sorry, LD, you're getting punchy. LD 675, contract for certain services. You are allowed to contract where there's utility services, refuse disposal, transportation, maintenance, financial services, insurance, security services, instructional materials, supplies, and equipment. For the love of God, you people who contract with Joskin, the ring company, and the yearbook companies for 5 years, 6 years, stop it. We get so many calls from administrators wanting to get out of these agreements. Do 1-year agreements with those people. It'll just save you a heck of a lot of heartache and problems. But in any event, we were able to get you out of those agreements for the last 20 years because their standard contract says 5 years. Well, it used to be able to 4-year limit. So basically, that contract was void from the minute you signed it. And so we would raise that with them and they could go away. That is now gone because they have extended the length of your ability to contract for these services from 4 years to 7 years. And so please, if you're gonna do a long-term agreement, give it a lot of thought, talk to your lawyer, talk to your board. We see more problems with long-term agreements than any other agreements that we sign. So be very careful when signing any of these 3-year, 4-year, 7-year deals.
Also talk to your English teacher, your, AD, your guidance, the people that, sometimes what happens. Yeah, ITs, we have people signing like long-term website management contracts and the school had no idea they were doing it. And Steve's right, we used to be able to get you out of them, but I'm not sure that's gonna be.
Yeah, I would cover in your in-services who is and is not able to sign contracts on behalf of the school. I would make clear that as an employee, they're gonna have problems if they're signing any of these deals on behalf of the school. It's just, it is amazing how many of these calls we get every single year. So I would address that topic and be proactive and make sure that you would. The maximum length of collective bargaining agreements was unchanged in that statute. It's still remains in place.
All right, 2 left. LB 630, this was a bill that Moorfeld initially introduced and then made its way to, I think, basically being kind of a full judiciary committee bill. It has
This was the hearing testimony where Ernie Chambers kept asking about sex with dead bodies. If any of you remember that, it was like a fever dream is what it was. Anyway, sorry.
So yeah, it was one of the most interesting afternoons I've ever spent over there, listening to the testimony. But there were a series of 3 or 4 bills that addressed this concept. This is the Maurice Washington running back for Nebraska situation. This is the sexting revenge porn. The concept of somebody has a nude picture and they try to use that nude picture to leverage something of value from the person who is depicted. We've always called it sextortion or revenge porn. There were a series of bills that were looking at targeting that concept. In addition to a bill that looked at adding what Texas has done, which is basically a civil liability statute. If you're somebody who uses that to try to extort something of value from somebody else. What ended up happening is they sort of swirled the main concepts of those bills together into LB 630. So under NDE Rule 10, you've got an obligation to train on digital citizenship. If you have one of us come out and speak to your students and staff about these issues, We love doing that, but we also include the stuff that you're required to under Rule 10. All of that training, so if you've had somebody out recently, whether it's us, a fellow educator, state patrol, and they've talked to kids about the consequences of sexting and revenge porn and cyberbullying and all that stuff, this bill has now changed several of those laws. So we highlighted to say that we're going to update all of our digital citizenship presentations for parents and students and staff. But if you have somebody resident in your district that's doing some of that too, like a counselor or principals, or you're contracting with somebody else, make sure that they've got you covered on these 630 changes, which do things like, change the criminal consequence for sexting, but they've done a lot more in terms of adding crimes, things like revenge porn and sextortion.
Last one, we've been banging the drum on these Title IX regulation changes for a while now, and we would be remiss if we didn't redraw your attention to that. We internally had kind of alternatively hoped and dreaded that the Title IX regulations would be finalized in time for the updates. They're not. The Department of Ed received over 100,000 different comments on the proposed changes to the Title IX regulations, and they're required by law to consider every single comment, whether they do or not, who knows. Their internal documents on their website show that their target is to have finalized regulations issued by September. Just kicking it around in here, we suspect that, I'm just guessing that means you'll have an effective date probably of, I'm guessing 1/1/2020. So this is just to put out there that there will be Title IX changes coming. Cody and Bobby have also pointed out different policies throughout this the discussion that are going to need to be tweaked when these regulations are finalized. So just, more to come, but keep an eye out for that. I suspect we'll have an update packet coming out in the fall after the regs are out.
Yeah, there's gonna be a whole bunch of new required training.
It could be, they could just decide to exempt us. It's theoretically possible that none of this will come to pass. Maybe, but we just don't know. So.
Yeah, I think I want to just put one small footnote in for those of you that haven't. The Fair Labor Standards Act is also set to change January 1, 2020. You haven't talked to your business officials, and if you're doing classified contracts, start that conversation now. And then handbook updates. We always get the question after the policies are out. We are literally working on those kind of as we speak. So we anticipate that those will be out, if not by the end of this week, then by the start of next week. So I don't know if you're somebody that absolutely has to have the handbooks approved in June, let us know. But what we've typically done is once we get the policy updates out, then we'll update the handbooks and send all those out as well. So those will be forthcoming.
So I've just changed the settings that now you may each unmute yourself if you want to ask a question by shouting it out instead of typing it. Then we'll just sit there awkwardly for a couple seconds while you decide if you have a question you want to ask. In general, I like it when you ask questions because whatever you ask is usually something somebody else is thinking of. But we'll give you a second.
Thanks, guys, for the update. This is Josh from Seward. I got a couple questions for you. To tell me the advantage or disadvantage, I know that it's not needed necessarily, but doing like a first reading of policies and then doing a second reading, is that worth the time and effort in your mind? Is my first question.
So my personal preference is not to tie yourself into 2 readings. I've just had so many situations where it's like, holy crap, our policy requires this and we don't want it to require this. So my vote would be not to do 2 readings. Most districts that we work with have like a policy committee that looks at stuff and then they bring it to the full board. So in my mind, that does the job of like double checking. Things that are big decisions like law enforcement unit, like do you want the principal sitting in when the cops are interviewing the kids? I've got no problem with the board considering that at 2 different meetings. But I don't think every single, like fixing the typo with the purchasing stuff, that's not worth 2 readings in my mind. So my preference is to do most of them on 1 reading. And then the things that are meaty, either have a committee look at first or just pull those out for 2 readings.
I agree with that. If you have a policy that requires that your hands are tied, if you don't have a policy that requires, you can still always do it whenever you want. And so that is my strong preference in that direction.
And if you've got our foreign policies, then it will say 1 reading, right? There's no requirement in there. So
What was your second question, Josh?
One of my second questions is essential oils has been brought to our attention a lot this year. Is there any good ideas, thoughts? We have said no, but then we've heard about parents wanting to have a doctor's note so then they could then administer it to the nurse, then could give it to them at noon or whatever. But what are your guys' thoughts on essential oils?
This is Bobby's expertise, so we're not done hazing him.
Yeah. So I've gotten a lot of questions on essential oils this year. I think the short answer is the federal government has not taken enough steps with essential oils that I would even consider a doctor saying they're necessary to treat them as medication under state law. We've got things like the Medication Aid Act that talks about prescription and non-prescription drugs. This is, to me, the equivalent of a kid whose parent wants them to take herbal supplements. I think allowing a parent to come to school to administer essential oils, you can, tell them, go hotbox in your car and use them if you want to. I don't have any problem with you saying to the parent, come to school and use them, but if I were in your shoes, Josh, I would not allow staff members to unilaterally, I don't care how much it's gonna improve test scores, I would not allow staff members to diffuse those things in their classrooms or in any other place where another staff member or student could be present, because there are a lot of actual articles and sort of news stories out there about people who've had really bad allergic reactions. They feel, if you are really, really into essential oils, and I promise I'm not trying to offend anybody on this if you are, but they feel strongly about them when they believe in them. To me, that's a separate question from whether we ought to allow them to be administered in the school for some reason. I would not subject my staff, either my school nurse or my folks that are certified as medication aides, I would not require them to administer those unless and until the federal government has said, yes, under state law, you should treat these as prescription or non-prescription medications. I think you could if you wanted to, based on a doctor's note, but I think allowing the parents to come and diffuse or administer them, just like you would for any sort of other weird herbal supplement, that it's not, CDC certified as a medication, that's how I treat it.
So just quick story, I was a hearing officer in a cancellation hearing or termination hearing. And as I was sitting up with the board, I had a little bit of a cold, but I was getting over it. And I coughed and coughed and coughed. And the court reporter was mad at me, and I was, freebasing cough drops. And I don't know what time it was, 10 o'clock at night, one of the board members, I was sitting in between these two board members, and one leaned over and said to the other one, "Oh, do you want some more essential oils? I've been using them." And I realized that I was coughing because I was having some kind of reaction to the fact that they were dousing themselves in these essential oils. So the idea that there are allergic reactions that are, not life-threatening, but certainly annoying, that's not, that rings true with me. So, I know people feel strongly about it. I like a little, eucalyptus after yoga, but I don't know that we want to get in the business of doing that.
Okay, thank you. And I just got one quick other question. Tell me about, we have found out that because of a block schedule at the high school, our attendance policy, then our attendance statement in our high school handbook varies a little bit different than our policy for excused and unexcused absences. Do you have any suggestions when those things occur?
Yes, send an email at ksp@kspschool.com. We'll help you tweak those to get them in alignment.
Okay. Thank you.
In fact, I am surprised that we don't have more of that kind of customization work, because that, in my mind, it's surprising we don't have it. That you should have these little tweaks that you need to make, and we're happy to help you do that.
Thank you.
Other questions? Okay, we will have this webinar recorded and on the website. If you have questions or board members have questions as these policies get rolled out in June meetings, let us know. Otherwise, have a great summer, guys, and we will see y'all soon.